Good morning, ladies and gentlemen. I think we should slowly but surely start for this panel on personalized pricing. Well, thank you very much for being here. My name is Ursula. Pachl. I'm the Deputy Director General of BEUC, and BEUC is the European Consumer Organization. The topic of price personalization seems to us a very pertinent topic. There is a lot of talk about personalization of services, but price personalization is something that we think has, of course, and can have a very profound impact on how our markets function and how consumers have powers or not in the relationship to traders. What we understand by personalized pricing is prices that are shown to consumers based on the data that the trader has obtained and on the analysis and use of that data. The most classical example for price personalization would be about a company's interest to maximize a company's profits by predicting what is the maximum amount that a consumer is probably willing to spend based on the knowledge that the trader would have about that consumer. And then there's always the question of evidence. Is this really going on? Is this just something that you hear about anecdotically? Is it something that is already widespread? There are, of course, already some research results. I would like to mention maybe two from our own community, from consumer organizations, Consumers International and Which, the UK consumer organization. They did research recently to show that dating apps, concretely it was Tinder, is adapting prices. They become more expensive the older you get. There was also reports about ride-sharing companies like Uber who would increase prices if they knew that your battery on your phone was getting low. So that is certainly a very disturbing example. And most of all, we know consumers hate price personalization. There is very high degrees of rejection of that practice. Consumers in general find it very unfair. And when I was waiting for the panel, I just met a consumer who I told about what we are going to discuss here. I think he's in the room, and he allowed me to mention it. So he experienced a Eurostar ticket booking as ranging with different attempts to book for himself and for his wife, with a price difference at the basically same moment within 5 minutes between 0 and 40. The price increased by €40 for the same ticket. So this is just another anecdote. Of course, there are also benefits. You could think that maybe people could get discounts, but this is also something that could happen, but we don't have a lot of evidence that it really works to the benefit of consumers. So what is this panel about? We want to see whether consumers will really end up in a bubble of their own. We call the panel a market of one, where people are left by themselves to understand whether they received a fair deal, whether there is a just price that they are going to pay, and what that means for markets and how they function. And the question is also, how should regulation respond to these challenges? I'm going to change now to introduce you to our distinguished speakers here on the panel. So I'm very happy. Sorry. Yes, so back on the microphone. To have here Gaetano Lapenta, who is an expert with the OECD, and he has done a lot of reports and coordinating research about competition law, including also reports about price personalization, and we're going to hear more from Gaetano on that research later on. We have here also Petra Leupold. I'm very happy because she's also coming from the consumer community, if I can say so. She's the head of the Academy of the Association of Consumer Information in Austria. She's also board member of NOIB, editor of the Journal of Consumer Law, and also a lecturer at several universities. Then we turn to Harmonie, Pontivianne. a hacker and lawyer with many different functions and hats on. If I may add only one concrete position that you hold, you're the Senior Data Security and Privacy Counsel at Eyeo. And Eyeo is a company that is doing ad filtering technology. Welcome. And then we have finally Aymeric Pontivianne from CNIL, and he's the head of the economic analysis team of CNIL, and also, and very interestingly, he's the co-chair of the EDPB's task force on the interplay between competition, consumer, and data protection law. And that, I didn't know it exists. I think it's relatively new. Can you confirm that? So that is a very interesting, I think, new development also, and very welcome and happy to have you there. So we are going to start with the first round of questions. The aim is to discuss a little bit what are potential harms for consumers and what is the current situation in terms of what we know, how consumers perceive that, but also what is the legal framework. So I start with Gaetano, asking you what I mentioned before about the research that has been published by the OECD. There was a behavioral study in 2021 on the effects of online disclosure of personalized pricing on consumers. So what happens if you tell consumers that there is personalized pricing? That was done in Ireland and in Chile. So the question is, what did the OECD find, and how does transparency change or not the behavior of consumers in these circumstances? Please, Gaetano.
So let me thank you first for inviting me here. I'm very glad to be here. So the short answer to your question would be no. Display disclosures obligations in that study we found didn't have any impact on the awareness of consumers about personalized pricing or on their purchasing behavior. We see an increasing recourse by regulators to transparency obligation, display disclosures obligation. And the idea there is simple. You inform consumers, and by informing and disclosing these strategies, then they're able to make informed decisions, choose on which websites they shop, from which retailers they buy, and so on. And we see that in a number of the directive, the Consumer Rights Directive, also in the recent DSA, all these display disclosures obligation. The question we asked ourselves were whether these display disclosures obligation are actually effective in raising awareness or changing or influencing consumers' purchasing behavior. We ran a lab experiment in Chile and in Ireland, as you mentioned, and we tried to make it as close as possible to a real-life online shopping experience. So participants had to set up an account online. They had to provide their personal data, which increased also their perception of price personalization, because they had already provided their personal data. They were then redirected to a homepage where they could shop, and they had to make 8 different subsequent purchases. For half of the items that were shown online, price was personalized. And for some of these, there was also a disclosure message saying that pricing was being personalized. There, I think an important aspect we also tried to assess was the impact of the strength of the disclosure message. So sometimes we used a stronger wording, sometimes a softer wording, which is what also happens online. And we found first that even when there was a strong message, display disclosure did not increase consumers' awareness. So still, even if consumers had been informed about the existence of personalized pricing, they were not able to identify price differences across different retailers. Just in Ireland, we found that when there was a stronger disclosure message, consumers were more aware of this strategy, but only after they had been informed about the potential effects of personalized pricing. We then found that the second finding of that study was that there was no impact on their purchasing behavior. So the share of consumers that were actually aware of personalized pricing remained the same whether or not there was this disclosure message, which is a very strong finding of that study. And when I'm talking about the majority of consumers not being aware of disclosure of personalized pricing, I'm talking about percentages around 90% of consumers that even if they had seen a message, they did not recall having seen the disclosure message about the existence of personalized pricing.
Sorry to interrupt you. So that means that you tell consumers that this is a personalized price, but they don't understand or they ignore? Or what is the finding really?
That's exactly the point. They ignored or they did not recall having seen the disclosure message about the existence of personalized pricing. They might, we tried also to investigate the reasons why at the end, within a short time frame, they did not recall having seen that message. And it could be that it was mixed with a number of other different disclosure requirements. It could be because it was taken for a piece of marketing from the retailer. In the end, around 90% of consumers, depending then on the strength of the disclosure message, did not recall seeing such a message about the existence of personalized pricing. And then just to conclude, I'll be very clear, also the perception of unfairness of personalized pricing was a bit generalized, but it then depended on the way in which personalized pricing was implemented. So it was implemented through personalized discounts, and you mentioned that before. It was perceived as fairer than when it was just based on targeted pricing. And also, of course, it depended also, the perception of fairness depended also on the criteria that were used for personalized pricing. When it was based on search history, participants in that study showed that they perceived this as fairer than when it was based on socioeconomic characteristics or the dependence of the consumer on the purchased product. So just to...
Okay, well, thank you, Aymeric. The question I would have is, of course, maybe they did not recall or ignored because it was not meaningful disclosure, but okay, that's another point I think we can come back to. Then with that in mind, I would switch to Petra. Petra, so tell us from your perspective, is it a harmful practice for consumers, the personalized pricing, and what do you say in terms of protection that is currently in place from different frameworks maybe to protect consumers from these negative impacts, please?
Yeah, thank you, Ursula. Thank you also for having me. I'm very happy to contribute to this panel. So our experiences with day-to-day consumer counseling kind of on the ground, and the fact that complaints concerning individuals' pricing are actually constantly on the rise confirm the findings of the research we just heard. So consumers, and I just want to mention that consumers consider it in majority as unfair. They are uncomfortable with these practices. They're concerned about the collection and processing of their personal data for those purposes, and they display a strong distrust in traders engaging in these practices. So those are our experiences. At the same time, and this also concurs with your findings, at the same time we see a strong sense of resignation. Consumers experience a lack of agency. They feel like they don't have a real choice in the matter, right? Which could also explain why it doesn't really have an effect, whether they take it or leave it, right? That they also engage in these transactions. And research shows that these concerns on the part of consumers are indeed reasonable, because individualized pricing does have a broad range of potentially very harmful effects, which from a consumer point of view should absolutely be taken seriously. And I will just point out these three main issues and concerns we have now from a consumer protection point of view. As a start, and Ursula, you mentioned this, we need to recognize that the implicit objective of personalized pricing is to maximize profit, right? So via reducing and extracting a consumer surplus. And this, of course, fair enough, right? Traders are no charity. We live in the market. However, from a policy point of view, it's highly problematic because traders have the technical means and the data to fully profile consumers and, of course, also to exploit their weaknesses in order to maximize their profits. And this takes the existing asymmetry and the already striking power imbalance between consumers and traders, of course, to a whole new level, right? So this is the first point. Also, price personalization inherently undermines price transparency, right? So without the ability to compare prices and to identify a reference price, like an objective market price, consumers cannot make informed choices. In the long run, with regard to also competition and the structuring and functioning of the market, in the long run, price personalization, and I think it's beautiful because a market for one, a market of one, right? Price personalization virtually means the erosion of traditional market pricing. Right? It's no less than the end of our rules and the law of the market as we know it. So it's also actually interesting from a cartel law point of view. And third point, the potential for exploitation is significant. Strategically, traders, of course, again, nothing illegitimate about that, have no incentive to reduce their base prices. So it can be seriously doubted, and you mentioned that the older economic theories were all about increasing market efficiency and consumer welfare as a whole, but instead it's more likely that it actually will only go up, right? Prices only go up, and that this will result in higher prices. And this again, of course, harms the most vulnerable consumers who are actually dependent on certain services and products. And it also harms the least sophisticated consumers, the least resourceful consumers who are not able to outsmart or bypass this kind of profiling and structuring, which of course is also detrimental from a consumer point of view because it's all about protecting vulnerable consumers. Second part of the question, like what is now the regulatory answer to this phenomenon? And I will give it a brief.
Petra, maybe we can be brief on that because we're only,
I will.
Maybe just very briefly, I think the basic question is from the angry consumer, is that possible? Is it allowed? Maybe you can say something on that.
So currently, as of now, personalized pricing is not directly, explicitly prohibited under EU law, but it touches upon several pieces of consumer legislation, and in fact, it actually runs counter to the very rationale of those consumer laws. I personally also think it's like majority, it's actually prohibited de facto under the GDPR, right? So first of all, we have Article 6 of the Consumer Rights Directive, as amended by the Omnibus Directive, which introduced a pre-contractual information obligation in May 2022, which requires the trader to inform consumers in a clear and comprehensible manner if they apply personalized pricing based on automated decision making. Just one comment on this article. So it has two prominent weak spots, right? Its scope is actually limited, and more importantly, the disclosure obligation is limited to the mere fact that prices are personalized. So the trader is not obligated to disclose the criteria used for personalization, and he also does not have to state a reference price. So we're again back to this take it or leave it approach. It's not meaningful enough information for the consumer to actually make an informed decision. And I think this is particularly interesting because the Consumer Rights Directive is all about enhancing informed decision making, right? So this is a rather weak policy tool from that perspective.
Petra, I have to interrupt you here because otherwise we are really running out of time. But so we have heard consumer law, the spirit would be probably prohibiting it, but I think nothing is specific. GDPR Article 22, big question mark, also for other things, not only for this very question, I would say. And then we'll move on afterwards also to competition law. But let me go to Harmonie now. So how How do you see that? Do you agree to the analysis that we just heard from Petra, for example? What are the benefits, if any, of personalized pricing from your perspective, and how could we alleviate the dangers that were just explained?
So I agree strongly with what Petra said, so maybe something else I can add to that is there is no way for a consumer right now to understand why the prices are personalized this way or this way. I'm going to start by giving a very personal and real example about that. So 2 weeks ago, I tried to purchase a train ticket from Paris to Strasbourg on the official website of SNCF. SNCF is the company in charge of trains and so on in France. So I was on the phone with a friend because she was trying to visit me. With 3 different browsers and privacy-preserving technologies, I have 3 different prices. For the same train ticket, I had a price of 39, another one at 32, and another one at 89 for the same train ticket. And the worst thing, she couldn't even see the ticket. When my friend on the phone was trying to buy this ticket, she couldn't even see it. And this is a real-life example. This is happening right now. Why? It's because the SNCF, without telling anybody, they made a deal with Criteo, and they don't even inform the users, the consumers.
So if you say she didn't see it, what does that mean?
She couldn't even buy this
she
train
didn't
ticket
get the offer.
in particular. And I
Yeah.
was on the phone with her, so the train ticket was available. She just couldn't see it. And something worse, I made some tests, and the best price I had, the 39 euro price, that was using a strong privacy-preserving product called Crumbs. And by using Crumbs, I had this ticket at 39. And when I was logged in with my professional G Suite account, that's where I had the 89 price. So I can have some clues on the why.
So can you go into that? So does it mean privacy-enhancing technology will give you lower prices?
In this case, very particular case, yes. By using privacy-preserving technologies, I had a lower price. But that doesn't mean it will be always the case because you had no clue what are the criteria, and that is the issue. That's why I really want to emphasize what Petra said about vulnerable people. They cannot even protect themselves about that, because in the GDPR, you can have some sort of transparency about the purposes, but you are not protected against the consequences of all these personal data collections about you. You have no clue. And even if you try, first off, it's super, super difficult. And you are not even sure that once you have revoked your consent, because supposedly you can revoke your consent to personal data processing. Right. You don't even know if after that you are protected because you have consented once to personal data processing.
Exactly. So very, very good insights here. So then I, of course, have to move now. Perfect bridge to Aymeric. So what are the privacy risks? What do you think? How does data protection law act in these circumstances, and what can consumers expect from GDPR? Thank you.
And first, thank you for having me on this panel. Actually, we are talking about first-party discrimination, as economists say. So the objective is to personalize the price and make it close to the individual, as close as possible, and reveal the consumer willingness to pay on an individual basis. So having said that, we understand why it is likely that the targeting and the data collection that used by the targeting is individualized, or at least highly targeted. There is an clear economic purpose for profit, as it has been said. And when you add on this the digital environment, you can understand why there are specific privacy issues with this practice. So what are the privacy and data protection risks from our point of view? The first one is the economic exploitation of data, because there are economic incentives to do so, as we can understand. The data are numerous and they can be combined. Contact details, identifiers, browsing data, purchases history, and these, when combined, this data can be very revealing for private life of individuals. And the economic exploitation of data, especially if the brokerage industry is involved. You refer to Gaetano. It can be a supplementary risk, and individuals can face loss of control. The second risk is the collection of sensitive data within the meaning of Article 9 GDPR, especially categories of data, like data regarding intentions and tastes of individuals. It can lead to exposure of sensitive data, even if it's not intentional from the controller, and those data are sensitive. Geolocation data as well are highly personal, and they can lead to re-identification risks. So we are very careful about that. The third risk is automatic targeting through pricing algorithms. You refer to them, and there are specific issues on that. With privacy issues of algorithm, explicability, which is a challenge, a risk of discrimination when it comes to pricing. There are examples on the ground, and as well the risk of data collection of vulnerable persons, which are magnified in case of individual pricing. So what are the answers provided by GDPR to those privacy risks? Briefly, because there are lots of principles on GDPR, and the principle of data minimization, for example, can be a protection, but just quoting some of them. Legal basis, Article 6 GDPR. It's not likely that a practice is such like a practice such as personalized pricing can enjoy the legal basis of legitimate interest in our views. So probably the right legal basis, as we can rule out as well the legal basis of processing of the contract, because the price personalization is not necessary to the carrying out of a contract. It would be basically the consent, so an opt-in requirement under GDPR for this practice. This is not judged by authorities, but if it were the case, it is likely that we would opt for such a requirement under consent.
Sorry, to interrupt you, Aymeric, does it mean that the GDPR would normally require consent in advance before a personalized price is shown to the consumer? Is that correct? Do I understand that rightly?
If we had the case to judge on, probably that it is an option we would take. This is not it's not stabilized, if you want, in terms of case law, but this is the likely option we would have, and everybody is aware of that. So the consent, an obligation to inform the consumer, the data subject / the consumer, you know that, prior to the processing. And this information requirement is very powerful because it exposes the purpose of the operation.
Oops. Okay.
So
I don't know what that means.
It exposes the purpose. So everything is exposed. Now, the purpose is to make profit and to exploit a consumer surplus, as you referred to. So, in terms of consumer information, do you want your consumer surplus to be exploited? Yes or no? this kind of information can be very strong in terms of consumer, and you talk of strength of the message. So the information requirement can be very strong. The last point is Article 22, as you referred to. If the processing is fully automatic, which is not always the case, but if it is, if you are purely algorithmic processing of the data,
which we have,
there is a stronger requirement under Article 22 GDPR. For example, it prohibits the use of sensitive data. It requires an explicit consent, so a stronger level of consent, and it's a good answer to the risks that we have talked about. Just it would be needed to admit to apply Article 22 that it has automatic personalized pricing has a substantial effect on rights. And it's not obvious. It can be the case in some situations, but probably not always. So in some situations, it could be a tool as well under GDPR.
Aymeric,
so to conclude,
yes, please.
Yes, I'm concluding.
We have to move on.
The GDPR does not forbid this practice, but it creates a very high regulatory standard to face the risks associated with personalized pricing.
Thank you very much, Aymeric, for this analysis. So theoretically, I think there are many options under the GDPR, as we just heard, a lot of question marks, and I understand no case law, of course, on Article 22, but even without Article 22, the legal base would probably be already a quite interesting protective element here. But let's maybe the second round do a little bit of that analysis and go further about enforcement possibilities and regulation frameworks. So I'm going back to you, Gaetano, with this very question. So what is the potential that we have currently in existing law? So be it competition, data protection, consumer law, what would you say? Is there enough protection? How would you see the situation?
The rules are there. They need to be enforced. I think one thing when you issue new regulations or you target new enforcement, I think one thing that should be really kept in mind, to follow up on what on my previous point before about consumers' awareness, is really to take into account consumers' inertia, consumers' bias, consumers' behavior online. We see that regulators more and more take that into account when they issue regulation. Just to, we've just in the past, to give an example outside of personalized pricing, regulators have heavily relied on data portability, for instance, to increase competition upstream. So the idea is that you grant the right to data portability, they will exercise it, and then this will enhance competition upstream. But because of consumers' inertia, this data portability rights and not brought the results that were expected in terms of increased competition upstream. And that's why recent regulations, taking consumers' inertia into account, they rely more and more on interoperability obligations that do not require any such a big activity by consumers. You see that in the DMA, relying more on interoperability than data portability, but you see that in the Open Banking Initiative in the UK, the Consumers' Rights Initiative applied to the banking sector in Australia. So you see that consumers' inertia is really in the mind of regulators. And I think that's also something that should be kept in mind also for personalized pricing. Transparency obligations, as I mentioned before, do not necessarily and always increase awareness or influence consumers' purchasing behavior.
Maybe,
so that's really...
Can I interrupt you there? Because if I rightly understand what Aymeric said, there should be information that you're being exploited, basically, right? So, would that not change consumer behavior? Because the study that you said, I don't know exactly how was the wording of the information that you said consumers would ignore, but let me just say maybe there is also a difference in terms of how you communicate about the purpose and what is going on there. Do you think that would make a difference from the behavioral insights that you have?
In the study we conducted, we actually assessed that aspect too. We tried to include different display disclosures messages and to assess the impact of the strength of the wording of
Right.
the
Including
disclosure.
you are being exploited?
Including not as clear, because retailers, I'm not sure that retailers will actually say that upfront. But we tried really to assess also the impact of the strength of the wording. And yet, we found that they did not really have an impact of consumers' awareness on how consumers recalled about the existence of...
I have to move on because we are really, it's very interesting, but we are running out of time. Let me pass to Petra quickly about how you think unfair personalized pricing practices could be tackled, please.
First of all, I want to strongly agree with Aymeric with regard to GDPR, right? So I do believe vastly that the collection and the processing of the data in order to show personalized prices is an illegal practice, right? That's the status quo, because the data collection process is not in line with. We don't have a legal basis for it. We don't have consent freely given. So this is what I just want to conclude from a legal standpoint too. So this is where we are. We have a massive enforcement issue, right? So. First of all, consumers do have, because you mentioned this Harmonie, consumers do have for these GDPR violations that are happening, they do have a right to compensation for their material or non-material damages. Very important, this breach of the GDPR, as well as breaches of the disclosure obligation under the Consumer Rights Directive, have a link to competition law. So competition law-wise, there are individual remedies of consumers too. They have a right to compensation under the UCPD as well, and they also have a right to price reduction if they paid a higher price, and to canceling the contract. However, we do know we have a massive access to justice issue, so individual litigation is just no real option for consumers, as we know from our experiences. And this is where the Representative Actions Directive comes into play. In my opinion, a real milestone step, which certainly will help to close this justice gap. And what's really important is that consumer organizations, as of June 25, that's when it will be applicable, will also have the possibility to conduct and launch representative action seeking injunctive as well as redress for consumers, also concerning GDPR violations. So the GDPR, its scope is extended now to the GDPR. It also applies to UCPD as well as to breaches of the Consumer Rights Directive. So this is potentially a really powerful tool, right? So we may see in the future representative actions launched by Neub, for example, in the privacy sector. Also in Germany, VZBV is very active. In Austria, VKI is very active, and this will extend to the GDPR as well.
Thank you. I have to interrupt you there. Before moving to Aymeric with an enforcement question and linking to what you just said, I think this is a perfect already anticipation of future enforcement and litigation strategies that Petra, you just pointed out. Let me go back to Harmonie just before and say, what do you think? What could be fair in this respect, and what regulation do we need? Do we need a ban on personalized pricing to get it clear-cut from the start?
I believe the change won't come only by regulations. We also need technical solutions to tackle these issues, and also maybe to have technical solutions so that would be faster than waiting for regulations to be enforced fully. What are the problems here? With personal of prices, we have the issue that it's based on personal data, and also the way personal data is collected, and also the content and so on. We already talked enough about the fact that currently this is not compliant. But it's part of a bigger ecosystem that relies on personalization of offers and ads in general based on personal data. So you already have some initiatives that tries to change the logic behind that. I won't talk about acceptable ads because this is not really relevant in here, but we have things like Topic API by Google or Crumbs, which are technologies trying to, rather than having personalization based on personal data, to have interest-based personalizations. So this is completely changing the way you have personalization to begin with. And transparency is a thing, but it's different than empowerment. Something else that is really lacking at the moment is empowerment of consumers. They don't really know on what they are tracked. So to have these interest-based presentations, first off, you as a consumer, you can know what are your interests, and also maybe you can have actions on that. And also something that can also help would be to have some personalization, but on a privacy-preserving way. So you can also have way more power if you want to change the way you are tracked differently. Because the issue with personal data, do you know where you can control your personal data at the moment? You don't have, as a consumer, the possibility to, in one single place, decide, I don't want my data to be used to personalize prices for me.
I think that's a very important point, and thank you for bringing this alternative concept up. But before we move to the audience, and you've been very patient, thank you for that. I would like to really now ask Aymeric about the interdisciplinarity of enforcement. And as I said in the beginning, you're heading a task force or a working group, if I rightly understand, at the EDPB about the competition, consumer law, and privacy or data protection legislation interdisciplinarity, and how do we address these problems with different networks of enforcers? Could you speak about that, please?
Yeah, thank you. Of course, there is a need of cross-regulatory enforcement, I would say, because the issues are. First, the individual is just one person. It can be qualified as a data subject or as a consumer, but it's one person, and the risks occurring to this person are multifaceted. For example, they are not only referring to data protection. There is competitive. There are competitive issues with personalized pricing, because the entities able to do personalized pricing are entities having a market power much often. An entity acting on a perfectly competitive market can't do this because the consumers reject it. So there is a specific issue of dealing at the same time with market power and with privacy issues on this kind of behavior, and maybe qualify it as a sign of abuse of dominance if an entity does that. And at the same time, it harms privacy of the individual. So, what kind of answer can we bring to
I'm
this?
sorry to interrupt you because we are running out of time. May I ask you, what is the objective of that task force? So, what are you going to achieve, and what are you discussing?
The objective of this task force is dealing precisely with this kind of case. The interplay between data protection, competition, and consumer protection. We have created this task force within the EDPB for 2 years, and we want to make sure that the interplay is done right, to avoid regulatory loopholes between authorities and between regulations, make implementation of the text coherent, and as well provide for legal certainty to the entities, the private entities concerned. So we We want to find the right cooperation patterns at national level and at EU level, because, for example, there will be a need for cooperation on this kind of issue, like personalized pricing, but on many other issues with the European Commission and the DMA. The implementation of the DMA, and we will need to have a discussion with the Commission Consumer Protection Network, where they are interplays between data protection and consumer protection.
Will you discuss personalized pricing now after this discussion? Will you bring it to your task force?
It will be on our work program, I think, for the months to come. And our ambition is to create a sort of common doctrine to provide for dialogue and hybridization of concepts and tools. But to conclude on that, it will be relevant and effective only if we know what happens on the market. And for this, as you said, there is an important role to play for civil society to signal us the case, the practices, and as well for consumer organizations like yours to have our work filled with the concrete cases and practices on the ground. This is important as well.
Thank you very much. I think this is really very, very important work that you're doing there, and something that it would be great if there would be more public discussion also about these the work that you're doing and the aim and the result of it, because I think we will need that cooperation very dearly also on other topics. But with that, I would like to now go to the audience. Sorry, I don't see very well. And I see there is already a queue. So thank you for that. And oopsie, let's open then with Frédéric, please. And if you're happy to identify yourself, please do so. And ask the question. I mean, tell me to who you ask the question, please. Thank you.
Hi, everybody. For whoever wants to react, there are a few practical examples in real life where price differentiation online leads to higher prices for poorer people. So basically making financial inequality worse. I was wondering whether any of you had some thoughts about it, for instance, from an economic perspective or from a legal perspective. Should we ban discrimination of poor people? Thank you.
Thank you very much. Who should respond? Is it to the whole panel?
Yeah, whoever.
Please. Petra, Gaetano?
Yeah, just a thought on that. I think, as Aymeric also mentioned, the likelihood of harmful effects from personalized pricing really depends on the existence of market power, on the extent of competition in the market. Harmful effects like those are much more likely to occur in markets where there's no competition. And I think that's something that's the source of in addition to all the privacy-related issues, I think there's a market power issue, as you mentioned, a lack of competition which enables firms to personalize pricing and to harm consumer welfare, to appropriate consumer surplus, as you also mentioned. By design, companies want to appropriate that consumer surplus, but whether they're able to do so really depends on the existence of market power. And I think that's the source of the problem that is not tackled, because we haven't seen any abuse of dominance cases, for instance, in this. And that's it might be for a number of different reasons, for burden of proof, how complex those cases are. But I think that's the source of the problems as the one that you mentioned.
Thank you.
Would like to add something else. One part of privacy is also, supposedly, you are able to choose what kind of information you want to share or not. And I don't like the verb hide, because this is not really, but normally you should be able to not disclose the fact that you are poor. And you have the right that even if you are poor, you don't want this information to be used, and especially not used against you. So as I mentioned and as I proposed, something that can be done could be to have personalization, but without personal data, or at least with the possibility to truly be in power of your personal data and privacy, and not disclose what you don't want to disclose.
Okay, yeah, thank you.
Maybe
Petra?
just one sentence. I concur with that finding. It's also what recent research shows. So this is exactly why we see the need to enhance protection because of consumer vulnerability with regard to that. And one remark, I do think with regard to the potential detrimental effects this has to especially vulnerable consumers, this actually might justify a ban of personalized pricing as such from a policy point of view. However, we heard, I mean, basically, I think it's illegal right now. So it would be important to drastically increase both public as well as private collective enforcement with regard to that. And one last remark, because it was also mentioned, we have the lack of transparency problem here. Also for consumer organizations, for privacy organizations, it's hard to have the evidence to actually conduct and launch those actions. So I think a reversal of the burden of proof would be of significant importance to enhance these kind of litigation and enforcement. So the trader should demonstrate that his or her pricing is actually in alliance and in accordance with GDPR, with the UCPD, and with the Consumer Rights Directive.
Thank you very much, Petra. So again, the question about is the burden on the consumer, even if there is a competitive market, which would maybe allow the consumers to deviate if he or she doesn't agree with personalization. Is it the consumer who has to try to find a deal that is transparent and good, or do we want to protect consumers, particularly the poorer ones? But there are a lot of questions. Please go ahead.
Hello, hi. I'm Neeti from Leiden University. I actually have two observations, questions, as you would like to call them. The first one is mostly for the entire panel, but the second one may be more relevant for Harmonie. The first one is that given the discussions about economic discrimination that is very closely tied to personalized pricing, do you think it's time to look at how GDPR treats financial data and give it a high level of protection, like move it to a sensitive category? Is that something that would probably help the situation a little bit? That's one. The other question I have is that, when Harmonie was giving the example of how the personalized availability of the train tickets changed and how the price went up, it sort of kept me thinking that we as educated consumers now keep relying more and more on privacy-enhancing technologies, and that sort of has created a secondary market for them. And so if we don't actually maybe call for an outright ban on personalized pricing, it seems that it becomes a little bit of a vicious circle. And so, what are your thoughts on that? Thank you.
Thank you very much. So financial data, sensitive data, and alternative means. So who wants to respond? Nobody? Who's jumping? I mean, maybe it's a GDPR question about the categorization of the data. What do you think, Aymeric?
On sensitive data, if I get your questions right, you ask how can we protect on a supplementary manner sensitive data as compared to basic data, not like this one, but the legal issue is not obvious on that because sometimes sensitive data are not collected and processed for the very nature of sensitive data and the sensitive information it brings to the controller, but they are sensitive, they are used by accident. For example, on financial data, when you collect, if you are an aggregator on top PSD2 and you collect banking data, banking account data of your client, there can be sensitive data on that by accident because the client has helped a charity of that religion, or it has it shows that it's they are going to a religious event on that day, not on the other one, and this kind of thing. So we shall be careful to in order not as well to block data collections because sensitive data are collected by accident as a small part of a bigger data lake and not used specifically. All the more that when you install technologies to isolate and eliminate sensitive data within a larger set of data, you reveal them to the eyes of the controller more than it were the case if they didn't have done this and treated just ignore them. So you have to be careful when you deal with sensitive data differently, not to trigger supplementary risks. Having said that, in terms of legal treatment, the legal ground to be able to gather sensitive data is much stronger than just a legal basis in the Article 6. You have to rely much more on consent, and legitimate interests are prohibited. So in cases where the sensitive data are used as such and can lead to discrimination, for example, they can be the prohibition could work relatively well in legal terms.
Okay, thank you. Harmonie, you want to respond to the second question?
Yeah, about the second question, I believe that, and I already said that, I believe the current way to personal pricing is completely wrong, because it's based on very personal surveillance. And in the example I gave, by using privacy-preserving technologies, I had a lower price, and this is already unfair. But imagine the other way around, to have some incentive with lower prices to accept heavy surveillance, because if you accept such a thing, you could have lower prices. And personally, I don't want to live in a world where everyone has some incentive to, because they would have lower prices because they accept surveillance. Because what does that mean? That means in a world where poor people that can't afford privacy would be completely tricked, accepting such a thing, and only rich people can afford privacy. I don't want to live in such a world.
Very good point. Thank you very much. So let's go to the next question, please.
Hi, I'm Surenas from Privacy Company, and I have 3 really brief questions about the example from Harmonie about personalized pricing by the state monopolist in France selling train tickets. So the question, of course, for the CNIL is, you said, okay, consent can be a legal ground for personalized pricing, but I don't think a monopolist like SNCF could ever obtain freely given consent. So I think I see an enforcement case coming here for the CNIL, and the way to start it would be Harmonie. Did you consider filing a data subject access request under the GDPR with the SNCF, where SNCF would have to pass on your request to Criteo, and Criteo would say, hey, but I can't reliably identify you based on the unique identifier in your tracking cookie. I can serve you with personalized pricing, but no, I can't identify you. And that's my final remark to Noib. Please launch a Europe-wide campaign asking for data subject access in these types of real-time bidding swamps. Thanks.
Very good ideas. So let's discuss them. Harmonie.
To be honest, I already had the idea to file a case here, but I will need the support and help with of other NGOs to really analyze how personalization of pricing is going on right there. And of course, if I'm here speaking about that, it's also because I want the CNIL to be aware of that. So can you give us maybe some insights of what you think about this particular case?
Wow, that's very direct.
No, it's very, very useful discussion, because we, as you know, GDPR implementation on the ground is a construction, and if we don't have the cases to qualify and judge about things, it's not possible to construct a legal answer a complex legal answer on a specific use case. So actually, why is enforcement on personal prices, GDPR enforcement on the personal prices issue maybe to lacking or to make better? It's because we don't have complaints. It's because we don't have reported practices on the ground, and so as I already said, the issue for us is to have the information and to have the practices and the evidence, lacking evidence, and having the evidence for the regulator, because the regulator cannot, forbid things from the blue, or being arbitrary in its practice. It's based on evidence and practices on the ground. So the right way to do it would be to have complaints, and maybe to gather these complaints. To have the action of a national consumer organization, like your members, your French members, having some kind of structured démarche to gather several cases and several practices and bring it in front of us, and then we can do our work.
I think the complaints are coming, Aymeric.
The regulation is a chain, and it starts with gathering practices.
Okay, thank you. Do you want to react quickly?
Well, thank you. Yeah, it's noted. It's on the to-do list, and also thank you, Aymeric. Just one follow-up question. I mean, this is something we actually hope to cooperate and exchange more information also in the future, because of the ex officio examination. Capacity also of the authorities, of course, right? So
thank you very much. We can, I think, take at least one more question. Please go ahead.
Hi, Andreas Heuselmann from Leiden University. To what extent do you think the fairness principle in the GDPR could be helpful to address the concerns around personalized pricing? Because if we think about EDPB's binding decisions in WhatsApp services and Instagram services and as well. So the EDPB stated that power balance or imbalance is one of the key concepts of components of the fairness principle. So what is your view on that? Why do regulators, for instance, not focus on the fairness principle? Because I think Gaetano also mentioned the rules are there, but they need to be enforced. And I think the fairness principle could be helpful.
Interesting question about the concept on fairness. By the way, also a very important concept in consumer law. I don't know, Petra, do you want to respond?
Yeah, maybe just one sentence because we're running out of time. Yeah, I agree. I think it would be very interesting to look into that more and to reinforce arguments also on that. Of course, it's like a slippery slope, right? It's the eternal discussion, it's the eternal argument, because that's like the killer argument for basically everything, right? But I do believe you can stress that and make the case, yeah.
Aymeric?
Just to add a word, fairness is a notion that typically can be used to help the dialogue between different regulations, because fairness, the GDPR talks about loyalty. Fairness is a key principle in consumer law. And market balance and the lack of the absence of abuses on the market is a key component of competition law. So typically, fairness, that kind of bridge, we can work on to fuel our regulatory dialogue, and this is what we will do in our EDPB task force.
Yeah, thank you very much for that, indeed. Can we have the next question, please?
Yeah, hi, my name is Jeff Ausloos from the University of Amsterdam. Just very quickly to Shura's point, a little birdie just whispered in my eyes that NOIP apparently has already, for 4 years, pending cases with the CNIL against Criteo, so maybe, yeah. So I think the ball is in the CNIL's camp, from what I hear. So as to my question, so I hear a lot that there's a lot of uncertainty on Article 22's interpretation when it comes to price discrimination, especially, and there's no real case law. Well, I'm happy to bring good news because there is actually case law, at least at a member state level. 2 months ago, the Court of Appeals in Amsterdam ruled in 3 landmark cases against Uber and Ola, quite explicitly and unequivocally ruled that drivers should be given the exact parameters for upfront pricing system, specifically applied to them, right? Not a generic privacy policy statement, but really the specific parameters in an understandable format that were used to set the price. More importantly also is that the court also said that trade secrecy cannot be used as a blanket sort of obstacle to say, I know we're not going to be transparent at all. It's what was not dealt explicitly with in this case is the other safeguards in Article 22, right to contest, for example, to contest the price discrimination. I see no reason why that would also be, by extension, applicable in these scenarios. So I'm wondering what the panelists think of this trend. Do you think it's enough? Do you think we need additional measures within the GDPR or outside? Thank you.
Thank you very much, Jeff, for this interesting news, good news. But let's see what our panel thinks about that. Who wants to respond? Article 22.
Well, just one sentence. Yeah, thank you. Super interesting. I'm wondering if that's a final decision. And I also do strongly hope that these cases, or this case, seems like a very suited one, will actually be referred to the European Court of Justice. It would be great. I mean, for me, it seems like, yeah, clear as day, this interpretation. But this would actually be a really important point to have like legal certainty with regard to also the European Court of Justice, just kind of labeling that and yeah.
Definitely, 100%. It's Court of Appeals. I have seen an Uber representative in this room, so maybe that person can comment if they wish to go to the Court of Justice.
Let's go to the European Court of Justice.
Okay. I don't know, I don't expect Uber now to show up, but anyways, we have a last question, and please go ahead.
Thank you. Raul Zakia, BCR. I wanted to ask a question regarding more regulated areas like banking and insurance, where, in my opinion, personal pricing might be an obligation because the law bounds the data controllers to collect data, to assess the data, and to give credit, for example, only to persons who will be able to pay back the money. So my question to Aymeric and whoever wants to jump in would be, do you think that you can base this processing activity on legal obligation or at least on contract performance? The processing activity consisting of performing the credit analysis and offer personal pricing towards
in the insurance
customer.
sector, mainly, I would say.
Or banking.
Or banking. Creditworthiness. Aymeric, what do you think?
The answer is, it depends from the provision you mean. If you refer to new insurance accounting principles leading entities to possibly individualize more the contract prices, I would tend to say there needs to be a clear link between the legal obligation and in the way it's worded and the practices. If there is a weak link or no link at all, or if just a link which is not really, material or strongly demonstrated, it doesn't work. So it really depends on which what is the provision you exactly mean in terms of EU law when you ask this.
There are more provisions, but there is not one not a specific one which bounds you to use personal pricing, obviously, but there are more provisions such as you need to check the credit bureau and other databases to you need to establish the income of your client, the level of indebtedness must be checked, and so on.
But I mean, maybe we have to, I don't know if you want to respond, but I think
Yes.
your answer was relatively clear, right? It depends really on the practice and how it relates.
It depends if we are talking about when you do a creditworthiness assessment, you do a scoring, and the bank will gives a price based on the credit risk of the client. It's not. Well, you can describe this as personal pricing, but it's more like a creditworthiness assessment for the purpose of a banking operation, and it's covered by European directive. It's organized by provisions. So yes, in a way you can call it personalized pricing, but it's already organized in a law, and it's not a general case. So in this case, the answer would be yes. There is clearly a legal obligation to do it under the relevant directive. I don't remember, but there is such a provision.
Well, thank you very much. I think we have exploited the time. I thought it was a very interesting, inspiring discussion with very good ideas. I think one conclusion I would like to take away is there is an issue with transparency. I would say it cannot remain the only measure in relation to personalized pricing. We need to enforce, and we maybe need to regulate more specifically. There is also an evaluation of consumer law currently ongoing by the European Commission, so that's also a place to look at. And I would like to maybe ask you to give a round of applause to our excellent panel. Thank you so much, and have a good afternoon. Thank you.